Welcome to the Probate Realtor Show, your one source for selling and buying real estate through trust and probate. Hear directly from the best attorneys and trusted advisors on how executors and administrators navigate the probate process in and out of court. Being a personal representative or successor trustee can be a daunting task, and often beneficiaries don't have a clear plan. Let us help you make the right decision for your clients, your family, and your legacy. And now, here's your host, the probate realtor himself, Matias Baker Masucci.
Welcome, everybody, to another very exciting episode of our show. Today, we are talking to Tamiel Holloway. Tamiel, welcome to the show.
Thank you.
Tamiel is an estate planning attorney that does estate planning and litigation as well. And what we're going to be talking about today is a very important subject, which is inheritance disputes. So, Tamiel, the first thing that I want to do for our audience is let's define it. What are inheritance disputes?
Well, I would say inheritance dispute is, after someone unfortunately passes away, they leave the will, the trust, and the beneficiaries or the actual beneficiaries are not in agreement with how it should be distributed.
Great. Thank you for doing that. So my first question is, what are some of the, in your experience, what are some of the common triggers that generally lead to inheritance disputes?
I would say oftentimes children that are omitted, or sometimes partners that are omitted, unfortunately undue influence by caretakers, or undue influence by, much younger partners, or what we call interlopers, people who maybe weren't traditionally or historically in the line of inheritance are suddenly claiming a benefit or have actual named benefit, and everybody doesn't agree. Right.
True. And how can somebody proactively sort of prevent, these disputes from happening? So you have seen it, you have the fortune that, by doing the planning, you also then get to see when the planning goes wrong. So when you're doing the planning, how are you advising your client and telling them, look, these are some of the things you got to keep in mind when you're doing your plannings, because you don't want your family to be fighting, even though they may do it anyway, over your money when you're dead.
I understand. I would say the best thing you could do is probably name all the potential heirs. I mean, really get it out on the table with your estate planner. Who is it that you would like to have inherit? Who is it that you wouldn't like to have inherit? You probably should share the why, even if it's a little embarrassing, because the more context you give your estate planner, the better they can help you strategize as to how to leave things and prevent disputes. I would say name all spouses, all partners, get it all out on the table and name everyone. It's very clear who should have been included, who shouldn't have been included. If there are even any children, for example, stepkids, nieces and nephews that you raised as your own, anyone who maybe even thinks that they're adopted, get it out on the table so that it can be addressed. I would also say if you have...
Oh, I say that makes total sense. Yes, please continue.
I was going to say also, if you have like a partner, I meet a lot of elderly people that aren't interested in sharing that they have a partner with their kids. They're afraid it's going to lead to like disputes or conflicts before they even pass away. So, consider maybe like some alternatives that might be like a little outside the box. I've seen adult adoptions. I've seen, secret domestic partnerships. There are ways that you can maybe put people in the line of inheritance that will kind of like cut down on disputes later without upsetting the status quo before you die.
That makes total sense. Oh, very nice. This is good. I've adult adoption, very, very, very well explained. Let me ask you something. It's kind of like a side way here. But you mentioned, put who you want to receive money and who you don't want to receive. You receive your inheritance. Now, I've, in my experience, I've seen that disinheritance often leads to litigation. So what are some of the things? It doesn't seem to be that easy. My son is a drug addict, so he's not going to get any of my money, but my other son, who's amazing, he's going to get all the money. And these things, have a tendency to trigger litigation. So my question, I guess, is related to disinheritance. How can you help somebody, if they do want to disinherit, somebody that, it would be, by code entitled to a portion of the estate? What are the strategies to make it sort of like work better?
Well, oftentimes it's really good to kind of leave that person a nominal, or in some cases, a not so nominal gift, because I'm sure most of us are familiar with a no contest clause. You know, you put in there, Jamie, you know, I'm leaving you just enough money to hopefully incentivize you not to problematize this and try to start litigation, because if you lose, you're going to get nothing. So I always tell people, like, be realistic about what that gift should be. I know historically people would say nominal gift, give them $1, but $1 doesn't incentivize anyone not to fight.
Right.
You know?
Yeah, that makes sense. So, you know, that is a great strategy. And thank you for sharing that with us. Another thing that I wanted to ask you about, it's, you know, generational differences and how, you know, they can impact, you know, litigation, I guess, inheritance dispute, essentially. I mean, you know, families have grandkids and kids, you know, somebody may have the same thing. Like, I'm thinking of an example, you know, I remember this, I'm originally from Italy, and in the south of Italy, it was very, very common, especially my father's generation, that everything was left to the male of the family. And the woman didn't, supposedly, you know, the woman inherited what her husband would inherit. So that kind of was the strategy. Obviously, you know, nowadays it's not like that anymore, but it makes me think, you know, when somebody has grandkids, or, you know, like, and they want to make sure that everybody's included, how are these, you know, how can, you know, different way of thinking, like, kind of sort of like affect the dispute process?
I mean, I guess I would say, like, one thing, I guess, generationally that we're seeing now is I think people are less afraid to start creating trust within their trust,
Right.
to benefit certain people. I always tell people to be, like, really realistic about their family members. I think historically people would say, like, well, like you said, my oldest son is probably the person who needs to distribute my estate because that just happens to be my oldest son, and that's the way things are done. But if your oldest son is not good with money,
Right.
maybe he shouldn't do it. And it's always okay. I tell people to, like, play to people's strengths, you know, divide the job. You know, maybe the oldest son is really good at personal care. So if you have to have someone acting as a power of attorney for you before you die, you know, let's, you know, have him do your healthcare directive issues, get you to the doctor's appointments, and maybe have that daughter, you know, actually take care of the finances. So, like, dividing the jobs, I feel like, is something people are getting more comfortable with, and creating sub-trust. They're like, you know, I'm a millennial, but I understand, you know, my grandparents didn't have the same ideas that I have about money. So I tell people that generation, if you're concerned that they're not going to spend it the way you think that it should be spent, put it in a trust until they reach the age of majority that you think is going to be appropriate. You know, it's okay to say when you're 25, when you're 30, you can have more access to this money. But if you need to go to college, we'll put this other person in charge of it for now. You know, so I think those are things we're starting to see. Also, some of the other issues generationally, I think people are more comfortable with people's sexual orientation. People are more comfortable. You don't see so many people being overtly disinherited for lifestyle choices, which is really great. And occasionally we still do. And, you know, as an estate planner, I try to flesh that out with people, like, let's really get to the bottom of this. You know, why aren't we really saying this? You know, and how do we really feel about this person apart from maybe like one choice or two choices that you feel they made?
That makes total sense. Thank you. That's actually very good advice, especially, you know, the you know, increments of giving, you know, like when somebody turns 18, if you happen to, you know, to be deceased before your kids, you know, or they stand to inherit, maybe they shouldn't be inheriting all that money right away. Maybe they could get a little bit at 18, some at 25, you know, and all of that, or 21, or whatever that may be. So that's very good. Another question that I wanted to ask you is, how can, you know, a successor trustee or a conservatory, because, you know, you work in conservatorship, which is, you know, it's a whole other animal, if you will, assure transparency, you know, to make sure that, you know, the people that stand to benefit from, you know, from the estate do not initiate litigation or have questions. So how do you advise, you know, your conservator, you know, or, you know, successor trustee or personal representatives to, you know, make sure that transparency is key? So how do you advise they go about that?
Well, you know, I always tell people, like, if you're not sure, and if you probably didn't go to law school, you should seek counsel and let your counsel do the talking for you. I think a big issue that I run into with people in conservatorships or in trust litigation is there's a temptation to start forming like factions and secret alliances with people and to make promises or side deals and then not understanding the full implications of those things that you're saying. So don't try to solve any potential disputes on your own, I would say. If you want to get ahead of it, there's always mediation. There's always alternative dispute resolution if there needs to be a formal process. But honestly, two attorneys sitting down can work out a lot of issues and we can work through a lot of resolutions. You can be there, you could not be there. Just trust your counsel. Don't try to go it alone. It backfires often for people.
I always say this, I remember reading a quote that says, the attorney who has themselves as a client in court, something like as a fool for a client or something like that, like I personally, I see that in, going pro pair, it's in probate, I always advise against it. Like every time somebody reach out to me and say, oh, we have to sell, I don't have an attorney. I'm like, oh boy, you're gonna have some issues, try to. No, because I mean, the truth of the matter, the audience gotta know, like you have notice, you have statutory notices that you have to file and things like that. You may not want to worry about those things. You have so many things on your mind already. Why, and if you fail to comply with the code, there are consequences. You are not able to take the actions that you want to take. So in the end, and it, you know what, in a sense, it's also, I feel the same way about for sale by owner, people who try to sell their own real estate, especially in Los Angeles. It's just like, okay, do what you will, but
it could be tough. I mean, tax implications, there's all kinds of things, but I think you're right. Like, don't try to go it alone. And if I also tell people the settler, the truster, the person whose estate is in question when they're alive, like get it out on the table and try to work through some of this stuff ahead of time so that everyone's not surprised and you leave a big mess for your successor trustee.
That makes total sense. Thank you for explaining that. Let's talk about briefly, because you're a mediator as well. Let's talk about alternative resolution and how these things, in your experience, have you seen much success? What role does it play, alternative dispute resolution in inheritance disputes?
It plays a major role in keeping costs down, and I would say in maximizing inheritance, because the cost of litigation can be staggering. I mean, the amount of time it takes for everyone to complete formal discovery, one phone call between one attorney and another, I mean, things really start to add up fast. And if you start to take, for example, as a client, take things personally, and you start bringing your, personal childhood conflicts to the attorney, it can get really expensive with the back and the forth and the he said and the she said. I would say sitting down, talking to an experienced mediator, or if there's like some neutral person who can comment, it saves so much, and it really helps save relationships if you can do it early. If you see a conflict coming, if you have an issue with something, the earlier you guys can sit down and talk about it, probably the less likely relationships are going to end up really strained. Because the longer these things drag out, the harder it is to sit down at the table for the holidays with that person. So
that makes total sense. Okay, let's talk a little bit about you, because I as I did my research, your bio is extremely fascinating. One of the things that where did you grow up, first of all? Let me ask you that.
I'm from Los Angeles. I grew up in Lamar Park.
Nice, very nice. And you, in your immediate family, there are many attorneys, right?
Yes, my parents met in law school, and then spread the idea that everyone should attend. I went, my brother went. I have a sister who's probably going to go. So I think we're going to keep it going. My husband's an attorney.
Oh, that's it.
Yeah, I spend a lot of time with people who are too verbose.
Wonderful. That's a good way to put it. That's great. Now, let me ask you, what was the journey? When you went to law school, first of all, do your parents practice the same law that you practice, estate planning and litigation?
Yes, they did. Actually, my dad, when I was very young, he did a lot more very criminal stuff and dependency. But by the time I graduated from high school, he was pretty firmly in the probate world.
That makes sense. So I guess, was it a difficult decision when you went to law school, and after you graduated, where you think like, okay, I don't know where I'm going to go, or were you always like, okay, I think, the estate planning and probate conservatorship world is probably where I'm going to end up? Or is that a decision that you made later on?
It was a decision I made later on. Like when I first graduated, I actually did like civil dependency work.
Okay.
Helping, family conflicts, children requiring assistance in schools. And after about a year of that, I was more interested in moving into probate, just because it just seemed like I didn't have the best experience with family law. I just felt like no one ever walked away happy. No one ever felt like, the resolution really met their needs. And I feel like in probate, you have not, most of the time, everyone's not happy, but I think everybody walks away feeling like there was some resolution there that they can live with, which seems to sit better than that it did in the family law world. So that's kind of what helped me make that shift.
That makes total sense. Thank you for sharing that. Now, there's other fascinating things about you that I want to ask you, because I'm so interested. You speak Spanish, and you end up spending some time in Mexico and Spain. When did that happen? Was that before law school, after law school?
Before law school, I was an international relations major.
Oh, okay.
And part of my major was to take a second language, and I just kind of kept on with Spanish. I really fell in love with it. And then I went to Mexico, and I interned at El Universal, the newspaper. And then I went to Spain. And then after I graduated, I said, you know what, I really think I could polish up on my language skills. So I said, I'm going to spend some more time there. I worked in the schools, and it's just really rewarding. I still use it. I mean, I live in Los Angeles, so obviously.
Right. Yeah.
Plenty of opportunity.
Plenty of opportunity.
It's nice to connect with people, and connect with people in their own native language. It's always really pleasant. That's
wonderful. And in our city, it's definitely an underserved community when it comes to estate planning, because a lot of the properties that I end up selling are, from people that didn't make any estate plans. Trust sales are much easier to do, when you go through probate. So that's great that there are people out there who can serve people, in Spanish, which is awesome and somewhat rare. I wanted to ask you something else now. This is how I end my shows all the time. So I have a list of 30 questions, and I want you to pick a random number. So you'll be responsible for the question that I ask you between 1 and 30.
7.
All right, 7. What sound or noise do you love?
I have to say, I guess my kids, like the baby voices. Like I have a 5-year-old and 2-year-old, and it's just like, I always think like my heart's going to break when their voices change, but it's just so sweet.
I agree 100%. One of the things that I say all the time is that when I come home and I open the door and I say, Papa is home, that sound of tun, 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 which is I have 4 little kids, the pitter patter of their tun, 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 tun when they're coming, that is my favorite sound in the universe.
I know. It's really rewarding. I love it.
Yeah, definitely. Wow. That's great. You are a mother of 2, and you have a career, and we haven't mentioned this to the audience, but you run your own firm, which is Holloway and Kimberlin LLP. So another important thing that I want everybody to know is, what is the best way when somebody needs to hire you? We will have your contact info in our show notes, but for those who are just listening, what is the best way to reach you?
Email.
Okay, perfect. Answer right there. Email. Do you want to read out your email for our audience?
Sure. Yeah, it's very long, so I'll just make it easier. T as in Tom, A as in Apple, M as in Mary, I as in Isaac, E as in Elliot, L as in Larry, at Holloway, HOLLOWAY, Kimberlin, KIMBERLIN.com.
Perfect. Thank you so much, Tamiel. It's been such a pleasure to have you on the show. You've provided so many interesting information for our audience. So I'm very grateful for that. And we look forward. I will probably, you've been you're so good at explaining things that maybe, I'll reach out and we'll have you back on the show at some point.
No, thank you so much. I would love to.
Of course. Okay. Bye, everybody. Thank you for joining us for this episode. We'll see you on the next episode. Bye.
Thank you for listening to the Probate Realtor Show. Find more episodes and interact with us at probaterealtor.la. That's probaterealtor.la. Listen, ask questions, and get results. Don't forget to like and subscribe. The probate realtor Matias Baker Masucci is a licensed real estate broker in California, DRE number 020547763. Any legal information provided is for informational purposes only and not for the purpose of providing legal advice. Contact an attorney to obtain advice with respect to any particular legal issue or problem. We make no guarantees as to the accuracy of any information. Thank you again for listening, and we'll see you in the next episode.